Hello friends, this is Sanjay. This is part 4 of the series where we are discussing Constitutional Law 1 and 2 as per the standard LLB syllabus. Download a PDF copy of the Constitution from the URL and after every session, read through the articles that we have covered. If you have any questions or if you feel that I have missed covering something important, then post a comment and I will try to cover it in one of the next videos. In this session, we will cover 3 articles under the right to freedom, that is 20, 21 and 22. And 2 articles under the right against exploitation, which are 23 and 24. We have already covered 19 and 21A in the previous session. The reason I'm covering these 3 articles, 20, 21 and 22 separately, is because they deal with protection in the context of criminal law. While covering Article 20, we will discuss protection against ex post facto laws, protection against double jeopardy, and protection against self-incrimination. Article 20 talks about the fundamental right of protection in respect to conviction for offences. This article has 3 clauses. The first clause essentially provides protection against ex post facto laws. The second clause provides protection against double jeopardy. And the third clause provides protection against self-incrimination. We will understand what each of these protections actually mean. The phrase ex post facto means from a thing done afterward. That is, done after the fact. For example, if you go to a normal restaurant, you can pay the bill ex post facto. That is, after you have finished eating. If you go to a self-service restaurant, you will pay the bill ex ante facto. That is, you pay the money before you eat. Clause 1 of Article 20 has 2 parts. The first part says that no person shall be convicted of any offence except for violation of a law in force at the time of the commission of the act charged as an offence. For example, in 2016, electronic cigarettes started becoming popular in India, and many business persons started to import, distribute and sell them. Till the 17th of September of 2019, there was no law in force that banned e-cigarettes in India. In 2019, the government passed the act that banned the import, distribution and sale of electronic cigarettes. When the law came into force from 0 hours 0 minutes on the 18th of September of 2019, dealing with e-cigarettes became illegal. Now, if you look at who can be prosecuted under the law, it is very clear. Those who stopped from the 18th onwards should not be prosecuted. Those who continued to import, distribute or sell even after the law came into force should be prosecuted. But you cannot prosecute someone who was dealing with e-cigarettes on the 17th of September because the law was still not in force as on that date. This is what protection against ex post facto laws is all about. It says that a person cannot be prosecuted under a law that came into force after the act was committed, even when that act is declared as an offence from the date when the law came into force. The second part of the clause says that a person should not be subjected to a penalty greater than that which might have been inflicted under the law in force at the time of the commission of the offence. Suppose there was a shop selling e-cigarettes on the 18th of September when they had become illegal. The authorities take action, they seize the stocks and start the prosecution of the person. Now the punishment prescribed under the law as on that date was 6 months imprisonment or 50,000 rupees fine or both. When the prosecution was still underway, the government decided to enhance the punishment to 1 year imprisonment and 1 lakh rupees fine or both. Now, when the prosecution is completed and the punishment is awarded, it can only be as per what it was when the offence was committed and not what it was increased to later, which means that the maximum penalty that could be imposed in this specific example would be 6 months imprisonment or 50,000 rupees fine or both, and not what it was increased to later on, because the amendments came into force after the offence was committed and they are ex post facto laws. Next, let us look at the second clause of Article 20, which offers protection against double jeopardy. The term double jeopardy means a double risk or double disadvantage. The article says that no person shall be prosecuted and punished for the same offence more than once. This is quite simple to understand if we look at when this protection will apply and when it will not. Suppose in an incident, if the accused person is alleged to have physically attacked a victim with the intent to cause death, and the victim is seriously injured in that attack. Then you can prosecute the accused once for that particular crime, and the prosecution may lead to a conviction or an acquittal. Suppose the accused person is acquitted. An appeal can be filed in a higher court against the decision. But a new prosecution cannot be launched for the same crime just because the accused got acquitted and the victim or the lawyers don't agree with the court's decision. It makes sense to draw this line because once the prosecution has had the opportunity to present all the evidence and argue the case, then the decision by the court should be considered as final. It can be appealed, but the entire prosecution cannot be restarted. But this protection will not apply if there is a different offence that stems from the same act. For example, if the victim of the attack dies after a few days because of the injuries sustained during the attack, then the previous prosecution was for attempted murder and the new prosecution can be for murder. Because even though there was only one attack, the offence in the previous prosecution was different. Similarly, double jeopardy protection will not apply if there is a change in facts. For example, if the initial prosecution was regarding an attack using sharp objects, and later it was found out that the accused person also used some illegal firearms, then the new prosecution can happen under the Arms Act of 1959. Because even though we are talking about the same incident, the offence is different. And also, if due to any reason the previous prosecution was not completed, that is, it did not lead to a conviction or an acquittal, but it was withdrawn or terminated, then the prosecution can restart because the previous prosecution was not concluded and the double jeopardy protection will not apply. The third clause of Article 20 states that no person accused of any offence shall be compelled to be a witness against himself. The word compelled means to bring about something by using force or to make a person do something by using force or pressure. In the Selvi vs. State of Karnataka case, the court clarified that the protection under Article 20 Clause 3 is applicable when a person is accused or is a suspect or is a witness. But if a person who is not an accused or a suspect or a witness and the person is just generally and voluntarily talking about something and during the course of the conversation reveals any information that can be used against him, then such evidence is usable. So, when does the protection under Article 20 Clause 3 come into play? When a person is accused or suspected of an offence. For example, if the person is named in an FIR. Or there is a compulsion to be a witness, and such compulsion has or could result in his giving evidence against himself. And what are the protections under this article? First of all, the accused, the suspect or the witness cannot be forced to make any statement that may incriminate them, and any statements made by them under duress or compulsion cannot be used against them in the court. Article 21 covers the protection of life and personal liberty. It states that no person shall be deprived of his life or personal liberty except according to procedure established by law. If the article only stated the first part, then it would be an absolute right. But the second part, except according to procedure established by law, says that this is not an absolute right. The second part says that the government can make laws that may negatively affect the life and liberty of persons in India, including citizens. Now, this term, life and personal liberty, has been defined quite expansively by the courts in various landmark judgments. For example, it includes the right to live with human dignity, the right to clean environment, the rights to reputation and privacy, the rights to livelihood, shelter and food, the right to free legal aid and a speedy trial, and it also includes the right to go abroad. If you remember when we discussed about Article 19 Clause 1, I mentioned that the Supreme Court held that the right to know is a fundamental right under the freedom of speech and expression. The Supreme Court has held that even Article 21 can be interpreted to include the right to know or the right to information. Let us now look at the exceptions provided to the rights under Article 21, which are the interpretations of the second part, except according to procedure established by law, which means that there must be a law justifying interference with the person's life or personal liberty, and the interference cannot be done just by using executive orders. And the law should be a valid law, which means that the law should not violate Articles 14 and 19 and should not have been declared as unconstitutional by the courts. And the procedure laid down by that law should have been strictly followed. And the procedure should be fair, just and reasonable. Let us now move on to Article 22, which guarantees protection against arrest and detention in certain cases. This is a lengthy article with 7 clauses and several subclauses, but they are all quite simple and easy to understand. Before we discuss them in detail, I would suggest that you should pause the video and read through the actual text of this entire article once, and I will explain the meanings of each of these clauses. The first clause says that a person who is arrested must be informed of the grounds for their arrest. For example, if a person is arrested for theft, then they must be told what they are being arrested for. It also says that if a person is arrested, they have the right to consult and to hire a lawyer of their choice to defend them in the court. The second clause mandates that every person who is arrested and detained in custody shall be produced before the nearest magistrate within 24 hours of their arrest. For example, if a person is arrested at 10 a.m. on a Monday, then the person must be brought before the nearest magistrate within 24 hours of arrest, which means by 10 a.m. on Tuesday. But the time required to travel to the nearest magistrate's court from the place of arrest is 5 hours. Then the person must be produced before the nearest magistrate by 3 p.m. on Tuesday, which is 24 hours plus the time required to travel to the nearest magistrate's court. This clause is specifically implemented through the relevant sections of the Criminal Procedure Code and the upcoming Bharatiya Nagarik Suraksha Sanhita. The third clause of Article 22 is an exception clause that allows for preventive detention, where individuals can be detained without being informed of the grounds for their arrest and without being defended by a lawyer. This clause is applicable in case of citizens of an enemy country, that is, enemy aliens, especially when there is a threat to national security, or when a person is detained under any law that allows for such preventive detention. The fourth clause can be interpreted such that when a person is to be detained under preventive detention for more than 3 months, then their case must first be reviewed by an advisory board. And in any case, the detention can only be as per a valid law that allows for detention beyond the 3-month period. And the maximum period of detention cannot exceed what is allowed as per such a law. In other words, preventive detention can only be for up to 3 months. If there is a need to detain a person for more than 3 months, there should be some law which allows it. And whether that law can be applied in the specific case is decided by the advisory board. The fifth clause says that when a person is detained under preventive detention, they have the right to be informed of the grounds or the reasons for the detention, and they also have the right to make a representation against it. But these two phrases, as soon as may be and the earliest opportunity, suggest that the decision as to when the person should be informed is left to the discretion of the authority. Unless, of course, the law under which the detention has been made specifies as to when and how the person should be informed. Clause 6 says that when a person under preventive detention is being told about the reasons behind the detention, the authorities can decide if disclosing any specific facts is against public interest. And such facts need not be disclosed to the person who has been placed under preventive detention. For example, if a person has been arrested on the basis of some intelligence reports or on the basis of information provided by informers, then revealing such information may go against national security or put the informer in danger. In such cases, the authorities may decide not to share the information with the detained person. And finally, Clause 7 of Article 22 gives the Parliament the powers to make any law that allows for preventive detention for periods longer than 3 months, without the need for the advisory board's opinion. and to decide the maximum period of preventive detention under any law, and also to specify the procedure to be followed by the advisory board. In other words, the period and procedure of preventive detention and the functioning of the advisory board can be completely determined by the Parliament by enacting valid laws. Articles 23 and 24 deal with the right against exploitation. Article 23 prohibits human trafficking and forced labor. Article 24 prohibits the employment of children below the age of 14 in any factory, in mines, or any other hazardous activities. These are simple articles, and as we will discuss, the scope of these articles has been significantly expanded by the courts through various landmark judgments. Article 23 prohibits traffic in human beings and also forced labor. So now, what is this human trafficking? It can be activities like buying or selling people, or it can be making money by forcing people to work. For example, there are people who procure children and force them to beg, which is a form of human trafficking that is illegal under this article. Now, the force that is used to make people work against their will can be physical, such as beating or threatening to beat. The force can be legal, such as the threat or the actual acts of seizing property, eviction from home, filing complaints or cases. In a landmark case, the Supreme Court held that even economic factors can be considered as force. For example, if people in a specific village are struggling to get food because of severe drought conditions, and a person takes advantage of the situation to make these people work at less than the minimum wage, then this too will be considered as forced labor because the person is taking undue advantage of the economic factors. In other landmark cases, the Supreme Court has expanded on the concept and meaning of forced labor to include other situations, such as taking undue advantage of poverty and other conditions to force a person to provide labor for less than the minimum wage, or forcing a person to work as a bonded laborer to pay off debt, or employment of people by the state, that is, the government, for less than the minimum wage. Even denying salary or wages for work that has already been completed is also considered to be a situation of forced labor. And all forms of forced labor are prohibited under Article 23. The second clause of Article 23 provides the exceptions to this article. It says that if the state, that is the government, imposes compulsory service or requisitions people for any public purpose, even if it is without payment or if the payment is less than the minimum wage, it will not be considered as forced labor. For example, if there is a war and the government mandates that all citizens of a particular age group must join the army or must work on manufacturing ammunition, then such work will be for a national purpose, for a public purpose, and such work will not come under forced labor. Similarly, if there is a large natural disaster like an earthquake and the government compulsorily enlists college students for emergency relief work, it will not be considered as forced labor even if there is no payment. The only condition here is that the compulsory service should not be limited to a specific set of people on the basis of only religion, race, caste, class, or any of them. That is, the compulsory service should not be discriminatory in nature. And to conclude the discussion on Article 23, as I have already mentioned in another video, any article which has a wide scope and multiple judicial interpretations will require specific acts or laws to actually implement it. So, the Immoral Traffic Prevention Act, the Bonded Labor Regulation Act, the Child Labor Regulation Act, the Minimum Wages Act are some of the statutes or laws that implement the protections mandated under Article 23. The Constitution of India has several articles which are aimed at protecting children and enabling their development, education, and health. Most articles cover adults as well as children. For example, Article 23 prohibits the trafficking of and forced labor by human beings, which obviously covers children as well. There are also some articles which specifically address the needs of children. Article 24 is one such provision, which prohibits the employment of children in factories and hazardous workplaces. Let us briefly look at this article, which comes under the category of fundamental rights. Article 24 covers the prohibition of employment of children in factories, etc. It says that no child below the age of 14 years shall be employed to work in any factory or mine or engaged in any other hazardous employment. While the article itself is quite self-explanatory, what is important here is the definition of hazardous employment. Now, the main act which implements this article is the Child Labour Prohibition and Regulation Act. And the schedule to this act contains the list of occupations that are deemed to be hazardous. But the list itself is not exhaustive, considering that there are new processes and new industries that are coming up quite frequently. So, the Supreme Court's interpretation of this term is also very important. The court held that any occupation that is likely to be injurious to the health or to the development of a child is a hazardous employment. In response to a writ petition called MC Mehta vs. State of Tamil Nadu, which is the Sivakasi fireworks related case, the Supreme Court released detailed guidelines on elimination of child labour in hazardous industries and occupations. The guidelines also aimed at regulating working hours of children in non-hazardous occupations also. Given that there are a very large number of industries, trades and occupations, there are several laws which have provisions to implement the protection of children as guaranteed under Article 24. These include the Child Labour Prohibition and Regulation Act, the Factories Act, the Apprentices Act, the Plantation Labour Act, the Mines Act, the Merchant Shipping Act, the Motor Transport Workers Act, the BD and Cigar Workers Conditions of Employment Act, and the Juvenile Justice, Care and Protection of Children Act. And with that, we have come to the end of this part. We will continue our discussion on Constitutional Law 1 and 2 in the next video. If you have any questions or feedback, post a comment and don't forget to like, share and subscribe. We will meet again in the next session. Take care and stay safe.